you know, take a real look at the hardships. The reason why I say that is essentially this. I take financial hardships very seriously because if people can't afford service for 6 weeks, I mean, for some of these people, that might result in them not being able to pay next month's rent.
You're not taking the rosters to the park.
Joel, do you on behalf of Rural Water Entities?
Scott Rasmussen on behalf of Hanna Instruments Inc.
Jim Neale and David Spurlock on behalf of UNFI.
Afternoon, Your Honor, Jim Cavanaugh for Real Water, Tennessee, LLC.
Robbins, Milwaukee Instruments.
All right, and gentlemen, I just want to advise you that my executive assistant, Lynn Berkheimer, sent you this afternoon or this morning. Yeah, this afternoon. Yesterday. Anyway, she sent a email to everyone, and it specifically is regarding what has to be done with the jury commission as far as, yeah. And I'll just read the first paragraph to you so you understand what's going on, because I know you potentially haven't seen her email. But as jury counsel, jury commissioner Witt has inquired as to the status of the jury excused from being counsel in the above case. As you know, once a juror is excused for cause or hardship, jury services must individually email or text each and every excused juror. This process must begin no later than August 28th and will be done in between their usual duties of processing jurors coming in that week and to sit for current trials. All excusers must be contacted no later than September 1st as trial begins on Tuesday, September 5th. I just kind of wanted to advise you of that because there are significant procedures Mariah has to go through as it pertains to contacting those that have been excused for hardship, because we don't want them to show up. And what I'm hoping is this, and I just have I haven't looked at the questionnaires. Are they doing a pretty good job of answering all questions for the most part?
Better than usual.
Better than usual?
I agree with that.
Yeah.
Well, I will say this, maybe, and Mariah did say this, me going down for every panel that came down there, because I actually spent about 10 to 15 minutes with them, going through the entire process, and explaining to them why they're there. And I explained to them, I told them, look, we're doing this for your convenience, so you don't have to sit around, and it might take an hour or two, and I got them to promise to fill it out completely. I administered the oath of voir dire to them. I also read to them a letter that was sent to me from a prior panel member that served, I think, for probably 2 weeks in the endoscopy cases, but he was ultimately dismissed. The reason why I read this letter to them because it's very insightful, because he actually says, Judge, I really, because I spend time on the preamble and all those things as we get started, just to kind of let the jury know why we're here. But and he talked about that. And I read it to them. And this was a gentleman that was a combat vet, 2 terms, 2 tours. And one was Desert Storm, the other was Desert Shield. And in his letter, he says he truly understood the
Plus he was Africa.
Yes, he did, that too. Yeah, and my point is this, he explains why he's here. And he says not everyone understands what it is to sacrifice a little of your time for justice. And it's a very compelling letter, and I read that to them. And so hopefully my time spent with them resulted in a better product as far as filling out the questionnaire. I told him, because I told him we're going to look at all of them, and but if you don't tell us how you feel and what the problems are, you'll be here. That's what I told him. Just want to let you know. So anyway, I guess bottom line is this: we have to at some point. Did we set a time period for a meeting on this? I thought we did.
I think we're meeting tomorrow on this year.
Tomorrow?
10:30.
Yes, Your Honor. We have done, the parties have gone through 4 series. We've provided the 5th series to plaintiffs. I imagine they will have that shortly to the court. And then we've received, obviously, a bunch of emails on recusals, or requests for excuses, rather. We'll get through those tonight, and then tomorrow the plan is to go through at least the first 4 sets, maybe in the first 5 sets, and see if we can reach agreements as to as to the other excusals.
Yes, Your Honor, I would just add to that, that we have been submitting to the jury commissioner all of the agreed upon excusals. So the first 4, all the agreed upon excusals have been submitted so that they've been able to reach those individuals. The 5th list we received this morning. We'll be able to turn that around by tomorrow. The 6th list, I'm not sure what the status is on that one. I'm not sure if we'll be able to get that by tomorrow or not, but certainly as soon as possible on potentially Monday.
Your Honor, just logistically, I don't know if this would be time to ask, but I was curious as to the court's process once we get to September 5th. We're going to bring in 100 at a time, or?
Probably, and that's a really good question, and it kind of segues into the next issue that I'll talk about briefly. But how many do we fit, Mr. Marshall?
66 in this courtroom at a time, Your Honor.
Okay, and that's all we have room for, correct?
Correct, Your Honor.
Yeah, that's all we can work with. And that's why it's kind of really important. I understand there might be issues regarding agreement, but you know, take a real look at the hardships. The reason why I say that is essentially this. My approach has been, for the most part, I take financial hardships very seriously, because if people can't afford service for 6 weeks, I mean, for some of these people, that might result in them not being able to pay next month's rent. You know, so I really I do. Like if it's a 1-week trial, then it's slightly different. Like we're talking, and I'll be honest with everyone, this case is going to take at least 2 months. I know. Some of you are optimistic. I'm a little pessimistic, and that could be 10 weeks. That's just how it goes. But we try to be efficient. And the reason why that's important is because the questionnaire does give time periods for the trial. And it's important to try to live up to those promises with the jury, right? It is. And so anyway, because I had a case, and I actually think that case impacted this case, where they went 2 weeks too long. And at the end of the day, and I've never done this, I had to put time restraints on them, because it had probably gone a month. You know, we'll see what the Supreme Court does with that. But, you know, when you make a promise to the jury 6 weeks, and now you're into week 8, that's a problem. And then we lost 1 panel member. We had 1 left, 1 alternate left. That's problematic. So we have to look at that. And just briefly, as far as Board is concerned, I don't mind telling everybody what my approach is. What I do, I'll spend about 2 or 3 hours getting the jury ready. I'll ask general questions of them and the like. And but nothing of any significant import in this regard, because my thrust and focus as the trial judge is essentially this. I want to make sure when I'm done that the jury understands why they're here, right? And the important role they play in our civil and criminal justice system. Secondly, and I do ask them questions about their beliefs, but this is very generic in a way. But I do spend time on what jury instructions are, because I want to make sure they understand that the jury instructions are the law of the case. And I spend time with that on them. And I want to make sure that at the end of the day, they can follow my instructions on the law. I want to make sure they understand that. I spend time with them. As far as jury selection in their general sense is concerned, I just want to remind everyone, you know, here in Nevada, we have Nevada Rules of Procedure 47A. And that deals with the trial judges, as the trial judge controls the voir dire. But I don't mind saying it, because there are cases from the 80s, and I remember back in the 1980s, it was my impression that the federal judges were the state court judges, like Judge White, Judge Mendoza, they were trying to adopt a federal model for jury selection. And so they were just, give me a written question, I'll ask them. Or, you got 15 minutes. And those are the types of cases that went up on appeal, and they were reversed and remanded, and they had to have a new jury trial. And so I tend to let lawyers do what they have to do as far as jury selection is concerned. Another thing too is this, and this is really important to understand because Nevada's a little bit different, and it's my impression as far as the thrust and focus of the jury selection is concerned, because we have Nevada Rule of Professional Responsibility 3.5A, right? And that's a rule of professional responsibility. And this is straight out of the rule, and this is what the rule says. It says, before the jury is sworn to try a cause, a lawyer may investigate the prospective jurors to ascertain any basis for challenge, right? And that's a rule of professional responsibility, right? And so what that says to me is this, and what is kind of implicit in that rule, and I don't mind telling everybody this, I took a deep dive as far as 3.5 is concerned. And I took a look at it, and this whole 3.5 comes from the ABA model rule, but it's my recollection when I looked at it, there was, from the ABA, we had A, B, C, and D, but there was no E. E appears to be, from what I can tell, Nevada specific. And it kind of makes sense when you look at a lot of the historical cases coming from Nevada as it pertains to jury selection, because we've just taken a different look at it. And so and understand, this is a rule from the Supreme Court, and all it says, basically, lawyers, you can't have any contact with the jurors except in open court, right? But you can have, it's pretty open-ended, right? And here's my point. It says any basis for challenge. Implicit in that is you have cause challenges, and you have 4 preempts. So you can ask general questions regarding those types of issues, and then also issues as it pertains to cause challenges. So that's kind of how I look at it. I'll let you do what you have to do. Of course, we have the qualifications requirement under NRS 6.010 as far as it relates to speaking English and age, disabilities, and all those things, right? So I don't think we have to go into that into great detail. We have NRS 6.020, and it deals with exemptions from jury service and those types of things. 6.030 deals with excusals, right? Now, here's a really important issue. And I'll just tell you how I look at this. And Nevada case law supports this, but I always, I look back and I look at, as it relates to cost challenges. And I don't mind saying this, I don't believe in rehabilitation. No rehabilitation. And here's my point. And you can take a look at this case, and this is a case from, I'm going to cite an 1807 case for you. How do you like that?
1807?
1807, right?
Really good.
But the reason why I think it's an important case is there's a discussion as the challenges from Chief Justice John Marshall at the time. He was, and the case is U.S. versus Burr, 25 Ed, case 49. It's an 1807 case. And understand, there's a lot of other cases I rely on this one, but the only reason, the primary reason I like this case is because of some of the language that was utilized by Chief Justice John Marshall in the case. It comes straight out of it. And I think and this is important too, when you look at John Marshall and you realize this was 1807, and I don't even know if they had, whether, I guess, psychology hadn't even been recognized at that time, right? And just as important, I know, some lawyers hire these high-priced jury consultants, and they have many different areas of discipline and so on and so on, and they're pretty good from evaluating people and so on and so on. But what John Marshall said to me is somewhat telling, because this was 1807, and I just like the language. And he says, quote, "Why do personal prejudices constitute a just cause of challenge? Solely because the individual who is under their influence is presumed to have a bias on his mind, which will prevent an impartial decision of the case, according to the testimony. And we kind of forget that, when they're here and you're examining, that's their testimony. But he goes further. He may declare, notwithstanding these prejudices, he is determined to listen to the evidence and be governed by it. And he goes further. He said, but the law will not trust him. He will listen with more favor to that testimony, which confirms, than to that which would change his opinion. It is not to be expected that he will weigh the evidence or argument as fairly as a man whose judgment is not made up in the case, close quote. And it just makes sense, And I think this is overlooked too, because remember, I'm just telling you how I handle voir dire. We have 47A, the trial court basically is given broad discretion as to how to handle voir dire. But remember this, there's no statute or rule out there, for example, that and this is a really good example because NRS 50.115 deals with the examination of witnesses, and you have a right to direct and cross-examination. There's no rule like that for voir dire. There's not, and if it is, tell me, maybe I overlooked it. But there's not, And so I kind of look at it from this perspective, and I think it might have been in Rich versus Mayo, one of those cases, and I forget which justice, I think it was, it'll come to me. But anyway, there was one of the trial courts went ahead and granted a peremptory challenge, cause challenge, in a very close, it was kind of a close issue. And at the end of the day, I think, it might have been Justice Seda, I'm not sure.
Is that Jitten, John?
Could be, but my point is this, she said it was harmless error when the trial judge granted it. But at the end of the day, I don't think it was harmless error. I don't think it was error at all. Because at the end of the day, he's evaluating the testimony and making a decision. If there's enough evidence to support that decision, it stands, right? That's how I look at it. But, as far as jury selection is concerned, I will let you do what you think is appropriate, as long as it follows the rules. I realize we have EDCR 7.70, and I'll tell you this, and we've had discussions about this at the judicial meetings, and I raised this. I think the rule is somewhat problematic, and just as important, it conflicts with 47A. And so what do you do when a Nevada Rule of Civil Procedure conflicts with an EDCR? Well, I think that rule of procedure takes precedent over it. But secondly, and I read it and I look at it, yeah, it makes sense. You shouldn't ask questions that have been asked and answered. We can kind of say that, right? We can. But it depends on who's been asked and who's answered, right? But it says, be questions touching upon anticipation instructions of the law. And we had discussions on this issue with a lot of the criminal judges and also the civil judges. And even the criminal judges really and truly question the viability of this rule. And the reason for it is this: one of the first things they do as it pertains to a death penalty case, they have the death penalty qualify the jury, right? And so they got to ask them, if I give you a jury instruction and you find this person is guilty for first-degree murder or whatever it might be, you understand that there could be a death penalty here. How do you feel about that? And you have to do that, right? But that's touching on jury instructions. In civil cases, all the time, lawyers will ask penetrating questions regarding how do you make your decisions in your day-to-day lives? Do you need a lot of evidence, or do you need maybe more likely true than not? And then some people will say, look, I can't make a decision under that standard. Can you make a decision in this case under this standard? If you can't, it might be problematic because that's going to be the jury instruction that's going to be given, right? That's kind of how it is. And so I just kind of wanted to go over that with you. If there's any questions pre-voir dire, since we're kind of talking about it, we'll touch on it a little bit tomorrow, I guess, maybe. You can ask me how I feel about certain things, and I'll let you know. Because when we start voir dire, hopefully we can be efficient with it and we get it done. But just as important, I let you do what you have to do, And here's my point. You might be asking questions that have nothing to do with or cause challenge, right? You could. But it might be very important from a psychological profile as to who you want on your jury. You know, and I'm not saying spend all day on it, but you might have some questions. And without a rule of professional responsibility says any basis for challenge, right? So you can ask those questions. So I tend to let you do what you have. And last but not least, try to be efficient. You know, that's all we can do. But any questions in that?
What time are we starting tomorrow with the jury questionnaires? We're just doing the hardship, correct, Your Honor?
Scott
Rasmussen.
Hardships.
Hardships, right? What time?
10:30.
10:30 is what I have, but.
10:30.
Okay.
She- she's
We just
the
bring
time-
down all the ones that are hardships and we just go through them. What is your plan? Is how
This
we
is
do
my
it efficiently?
plan. The ones you can agree to, you agree to. I'll accept that.
We've already agreed to many and they're already out. And they've been-
Okay.
So we're only talking about a stack of those that have not been agreed to is what we're bringing tomorrow.
Right.
Okay.
So we'll go through those.
Okay, and we'll start probably with the lowest number and then go to the highest number. Is that probably the best?
When you say, yeah.
So in other words, we have jury number one, let's say, that we saw in week one. We'll go with that one and all the way through to week 5. Now, we don't have week 6 ones, but we'll get there at some point.
Yes.
Is that the plan?
Makes perfect sense. And the reason why that's kind of important, because at the end of the day, they'll be placed in probably the box in the order upon which
Right.
they are.
Hey, Mr. Kemp, are we still taking up your MIL 19 prior to that?
I was going to talk to you about that. It seemed to me that it was problematic, and maybe you could give Mr. Hoffman a minute to help.
Let me know if you would. I'm happy to discuss it.
I don't see any reason to have to at this moment.
Okay.
You know, are we taking, I thought we were gonna take,
20.
20, hold on, I thought we were taking 16 next. MIL 16, that's the one, that was granted?
Right.
I have Millwater's motion for summary judgment re plaintiff's punitive damages.
Yeah, that's
Did we already hear number 16,
No.
plaintiff's motion limiting number 16?
No, the judge announced a ruling from the bench on the motion to strike that
It was granted?
presumably,
Okay, that's what I read in the transcript, that it was based upon what the court pronounced from the bench, that it would be granted, but I wasn't sure it was something that was done. If not, I want to just check the box and make sure it's done.
Yeah, Judge, I have the next one. Mr. Neale, Mr. Hoffman is going to argue this one, 19. He's not here today, and I don't really see any reason to bring that tomorrow because we may not get to it. The next one I see is motion number 20, Alcina, which is Mr. Parker's motion.
So is 16 granted or not granted?
I have it as moot.
Okay. And that's based on the court's pronouncement on Tuesday, correct?
Yes.
All right. So, Your Honor, there's one issue, if I could, that's related to number 16 that I thought we should just address, because it becomes an issue because of UNFW pretrial disclosures. The pretrial disclosures list witnesses that presumably would come in to testify regarding purchase data reflected in those Excel spreadsheets. One would be the attorney, Mr. John Hempling. The other would be Mr. Craig Shank. And so I want to make sure those witnesses aren't being brought in here to support a document that's being excluded.
I mean, there would be no reason for them to come based upon my decision, right?
That's what I believe, Your Honor, but I wanted to make sure for purposes of this completeness in terms of this motion.
we'll make a proffer of those witnesses' testimony for the record. We understand the court's order
I understand.
Okay, that addresses.
And
and take exception to it, of course,
But no, and we're gonna follow the appropriate thing to do.
Thank you, Your Honor.
We'll accept the proffer when the time comes. All right.
Your Honor, number 20 is a pretty easy motion.
If any of these motions.
I'm hoping it's easy. I'm hoping, for that. I'm hoping that 20 is easy.
Mr. Robbins needs to be here, and I think he had to step out briefly, and I'll see what I can do to get back in.
Yeah, we'll wait. Motion to include.
The Alcina one has to do with leave, right? Isn't it your Muslim number 20, Mr. Parker?
It is.
Okay, that has to do with Milwaukee, correct?
I don't think so.
I didn't think so, but
Maybe I'm wrong. I just read it, I was thinking.
This is real water. I think this is,
exclude Dr. Alcina.
right.
I have a paper copy if you need it.
So I had one too, and I thought that, I must have the wrong 20, my mistake. Joel, I apologize.
No worries.
Your Honor, you okay, Joel?
Yeah, I see what's going on there.
Chris, could you bring up plaintiff's exhibit, I'm sorry, plaintiff's motion on number 20? So, Your Honor, this motion was brought to preclude Dr. Alcina, which is a real water expert, from being able to provide testimony at the time of trial. We tried to take Dr. Alcina's deposition on more than one occasion. In fact, we requested several times to quote Dr. Alcina. For various reasons, he was never made available to us. We cited the rule NRCP 26B4, which of course allows us to notice the deposition and take the deposition. We cited NRCP 37B, which is the punishment for not producing a witness. This is one of the briefs I thought would be actually suitable for submitting it on the papers, Your Honor. Certainly the court's familiar with the cases we cited. We cited numerous cases, both in and out of our jurisdiction. But real water's opposition, Your Honor, is to me nothing more than an excuse as to why he could not give us his testimony. I think the excuse is that he was out of the country from May 12th through May 22nd, and we were never provided with reasonable alternative dates to take his deposition. The close of discovery was June 8th, 2023. The dates we got eventually were July 5th, July 6th, July 13th, and July 14th. All after the close of discovery, all of course impacting our ability to do pre-trial motions, Your Honor. And so this notice of unavailability that came on June 8th it's too late. It was the day before the close of discovery. There was no way in the world we could have taken his deposition within the discovery period, get the transcript back, and then use that testimony to support pre-trial motions, Your Honor. Rule 37 is clear that in a situation like this, the expert should be not allowed to give testimony. In fact, there are certain cases in the state of Nevada where the Supreme Court has struck the answer, the answer of the defendant when they fail to allow or provide a deponent for deposition. So unless the court has any questions, this is a pretty straightforward motion, Your Honor, and again, I didn't think this one would take very long to argue.
All right, thank you, sir.
Thank you.
Mr. Odou, sir.
Thank you, Your Honor. Joel Odou on behalf of Real Water. I will not be very long either. Your Honor, as the court's very well aware, this case was set for trial on an expedited basis due to the age of the unknown. We had a condensed discovery schedule in this matter. It was adequate. I will certainly not argue that. However, just as in life, people take vacations. In this case, the expert was on vacation, I believe, in Europe, and was unavailable for deposition in the deposition window. It's as simple as that. It's no different than if an attorney had taken a vacation. Litigation is litigation. We frequently make accommodations for people when they're unavailable. Dr. Alcina was out of the country. He provided July 5th. I recognize nobody likes to take a deposition after July 4th, but he provided July 5th, he provided July 6th, July 13th, July 14th. I would also add, Your Honor, that the case is cited by Mr. Parker about parties not appearing and the answers getting stricken is a case. When an expert is out of bounds, I would say, the expert gets stricken. And certainly I understand the plaintiff making that request. However, we frequently accommodate the schedule of witnesses. We did that in this case for other witnesses who were taken after the close of discovery. I'm not privy to why that occurred because it was with other experts. One of them still keeps getting notice for a deposition and then it gets canceled. So I'm not sure what's going on with that either, but it's a resumption of a deposition. Finally, Your Honor, I would note that the not taking Dr. Alcina's deposition did not prohibit the plaintiffs from filing a motion to eliminate on substantive grounds to exclude his opinion. So I think that's a bit of a straw man to say that they couldn't get a transcript or they couldn't get a stipulation from us to take the deposition on July 5th or later and file any motion they chose to file later. Certainly, we've had plenty of time in this case. And that's it, Your Honor. That's all I have to add.
Mr. Parker.
Yes, Your Honor. In the spirit of brevity, Your Honor, I'll make this short. Real Water never asked Special Master Hale for any accommodation, no relief, nothing. We asked for deposition dates as far back as May 1st, and never, and based upon the Real Water's opposition, Dr. Alcina was not available May 12th through the 22nd. What happened to the 11th?
What do you say, May 12th to the 22nd, you're talking the 22nd of May?
Yes, sir. And so I wonder what happened from May 1st to May 11th. We were never given any dates between that time. Real Water has no excuse for that. And you cannot impose upon the plaintiff to wait until after discovery is done. In fact, almost a month after discovery is done to provide dates. That simply does not work. It does not afford us the right or the ability to comply with the dispositive and pre-trial motion deadlines. It just doesn't work, though. And so we've not asked for the most severe sanctions. We've not asked to strike their answer. We've not asked for anything other than to prevent Dr. Alcina from testifying since he failed to give us any dates within the discovery period. And because Real Water did not ask for any relief through the special master. So as a result, Your Honor, we believe that Rule 37 is clear. If you do not comply with the deposition request, deposition notices, you don't show, this is the appropriate sanction.
And tell me, what type of expert is Dr. Alcina? What was he designated for?
Dr. Alcina would be commenting upon the plaintiff's injuries from and the severity of them. We anticipate, because of cumulative testimony, because of other issues that are happening in this case, that Dr. Alcina's testimony actually is going to get narrowed quite a bit. And if the court denies a future motion to eliminate on plaintiff's claims for future treatment, then Dr. Alcina would comment upon the need or lack thereof for future treatment by any plaintiffs. That's a motion to be heard that we have filed. But the testimony actually is going to be drastically limited now that we see where we're at in terms of the state of evidence in this case. So I don't see Dr. Alcina testifying to everything that's in his report anymore.
And I appreciate Mr. Odou's candid response to the court. In my opinion, Dr. Alcina's testimony at trial is, I don't know how it's necessary given that no one's disputing that all of the defendants suffered acute liver injuries. Plaintiffs. So
We've been here a long time. So
plus, I'm more accustomed to being on that side. But yeah, thank you, Scott. But Your Honor, that's correct. No one's really disputing the fact that the plaintiffs all suffered acute liver injuries.
Real Water.
And so I really don't see how Dr. Alcina's testimony is going to be that pivotal to Real Water. And that's probably why the opposition is what it is, and probably why both me and Mr. Odou are being so brief in our arguments. I think this is one that's properly, Dr. Alcina shouldn't be allowed to testify, but I don't really see the significant harm in the defendant's position given the acceptance by all the defendants that the plaintiffs all suffered acute liver injuries.
And the reason I'm asking, I mean, I haven't looked at his report, and this is one of those areas where I guess it came down to noticing the deposition. I understand we have discovery cut off and we have all the rules in place. I mean, I get that. And then we have a situation where, as far as Mr. Odou, he's been aggressively defending the case, right? He did.
I think Dr. Alcina put Mr. Odou in a tough spot. I think he put Real Water in a tough spot. The problem is we had the court's scheduling order and the special master's discovery dates and deadlines imposed since December 7th of 22. And we've asked for dates. We had a short window to do it, but we took every deposition, and I think the defendants took every deposition they chose to take. So Dr. Alcina is the outlier here, and I think there should be a punishment to Dr. Alcina for his failure to provide any dates that any of the defendants, whether the Real Water and claims to work with him. He gave us dates almost a month after the discovery closure on. And we gave them, there was at least 11 days within which both we offered and before he went on his vacation. So when you consider the close of discovery June 9th, his first available date, July 5th, just 4 days short of a full month after the discovery cutoff, there's no way in the world we could have done our pretrial motion, the dispositive motion, timely, not having his transcript back. So we couldn't take the deposition, we couldn't get the transcript, we couldn't fold that information into our pretrial motion practice. I mean, this is a suitable and just result under Rule 37 for his failure to make himself available.
Anything you want to add, Mr. Odou?
Just very briefly, clearly, there were other alternatives. You know, we asked for the extension, they denied the extension, that's very true. You know, there could have been an alternative arrangement. You know, you pay for the transcripts since we're going to have to expedite it, that sort of thing, but there was never a negotiation because it was, you know, if you can't make the window, then we're going to move to striking. And the window was pretty small.
No, I understand that. I mean, I'm looking at it. I get that. I do.
So that's it, Your Honor. Mr. Parker is right. They asked for it, we couldn't provide it.
Last word, Mr. Parker.
Yes, Your Honor. I appreciate what Mr. Odou said, and again, I'm directing this at Dr. Alcina. He put Real Water in a position where they couldn't provide dates within the discovery period, and he didn't give them dates even between May 1st and May 12th before he went on vacation. Again, that's Dr. Alcina's problem, and unfortunately, it's been inflicted on Real Water. But certainly it's not the plaintiff's burden to bear, Your Honor. The other thing that Mr. Pepperman pointed out, there's 113 pretrial motions this court has been handling. We could not have done all of those and take the deposition, wait for the transcript, and fold those motions into this practice. We would have missed the dates. And so then we would have been beyond the required dispositive and pretrial motion limiting deadline. So we couldn't put ourselves in that position. So, Your Honor, there's no other way of accommodating it. Otherwise, we've blown our chances to file motions related to his opinions. And the plaintiff shouldn't bear the brunt of Dr. Alcina's.
And I mean, I was thinking about it, and I was looking at it. Well, the problem is, we don't even have time.
We don't, Your Honor, and that's the problem.
Today's the 24th, tomorrow's the 25th. We're pulling, we'll start jury selection on the 5th, right?
Yes, sir. And taking a deposition during trial is not fun.
I know.
I totally agree with that, if that's what the court's going. I would note there is a motion, another motion on the number 24 concerning Dr. Alcina. So certainly there was time to to file a motion on his opinions anyway, so that's the only place I disagree with Mr. Parker.
All right. I think Mr. Odou, you kind of summed it up in a general sense. We can't take his deposition to a trial, right? We don't have time before then. And what is the other deposition, I mean, what is the other motion on? I'm just curious.
It's a substantive of his opinions. It's motion eliminating, plaintiff's motion eliminating 24. Under Williams, he's got a alternative cause opinion, which frankly is going to be moved. We're only going to be calling Dr. Alsina to comment on future treatment. We're actually going to be narrowing the scope. And then if our motion is granted to exclude future treatment, there would be no need for Dr. Alsina at all. It's kind of interesting though, because our motion is the same as theirs. They missed the deadline, and we filed our own motion on that, not to get ahead of ourselves.
And Mr. Abdul is correct. The plaintiff's motion, linear number 24, is to preclude Dr. Alsina's opinion under Williams in terms of alternative causation opinion using this computer assessment. Your Honor, that was one where a deposition drill down probably was unnecessary given the Williams decision. But you and I both know, in terms of testing opinions contained within a report, other than this one, which is pretty simple, the deposition is invaluable.
Yeah, can you two approach this one? Yeah. Okay. And gentlemen, what we're going to do is I'm going to defer ruling on this specific issue. I'm going to give you a chance to talk. And then if you need me to rule, I will.
Sounds good. Thank you so much. We appreciate the court's insight.
Assistance, yes.
Yeah.
Yes. Okay. Yes, you can do it. We can, let's go on to the next. That way we don't forget about it. Thank you. Okay,
We're at water motion for some judgment. With regards to punitives, before that, there's a motion to seal it.
is the motion is still uncontested?
It is, Your Honor.
Yeah, and the only issue I have with seal motions, I have no problem in granting them, but make sure I make the appropriate findings in the order, right under Rule 3 or whatever, Springfield rules.
Your Honor, you issued multiple minute orders on the motions to seal. I don't know specifically that this one was included, but you did in those minute orders instruct us to prepare the orders in accordance with the applicable rule on seal.
Yes, yeah. So I'll grant it, but make sure, because that's important, because what can happen 2 years down the road, the press can come in and say, Judge Williams, why did you seal this? Because they should have a right to findings, and just as important too, as far as this issue is concerned. I have to meet the requirements under the law and make findings. I think everyone understands.
Exhibit A.
Which motion to seal was that?
Yeah. Your Honor, we're just clarifying, this is Real Water of Tennessee's motion to seal on its summary judgment motion.
And it was uncontested, and I think it was granted with the minute order Mr. Pepperman already referred to. But if not, it should be granted. It's the supplier agreement, Your Honor, between UNFW and Real Water,
Tennessee.
Tennessee.
Yeah, it doesn't prejudice our right to use it at trial.
Of course.
But it was a confidential document that was,
And there's probably proprietary information that come under the purview of the law. I got it. I mean, when it comes to sealing, my big issue on sealing is essentially this, and or redact. I have to make the appropriate findings pursuant to the law to do that. I have no problem doing it. I just want to make sure that someone comes down the road 4 years from now and say, Judge Williams, why did you seal this? There's no appropriate order. I have no problem sealing it. I just want to make sure we have the appropriate order.
And it's Real Water Tennessee, just for
it's Real Water of Tennessee's,
So it's granted, just make sure I get the appropriate And maybe it has been granted already, I'm not sure.
I think it was already.
I don't know specifically.
But if it wasn't, make sure you make the appropriate findings for me under the rule.
Thank you, Your
And
Honor.
is that Supreme Court Rule 3? Is that it?
I believe so, yes, Your Honor.
Yes.
Thank you, Your Honor.
So, Your Honor, the next motion we show is Real Water Inc. and Affinity Lifestyles.com's motion for summary judgment on punitive damages.
I know I have one currently pending too, but I've been thinking about that one. Go ahead.
This one's a little different, Your Honor, and this will actually be fairly quick. It's only a 5-page motion, and let me lay out the issue, and then I want to make a correction because I was not happy we missed some language in the original motion. I want to make sure that we are representing accurately to the court the Lombardi case.
Right.
Because when I read it, I was like, that's not clear. And so I want to make sure that I'm clear what we're saying. Your Honor, as the court is very well aware, the real water entities are bankrupt. There is a stipulation set aside to stay to pursue insurance proceeds whereby the real water entities will be nominal parties to this case. As part of the claim in this case, there's a claim for punitive damages against those entities. The case that we cited is Lombardi versus Maryland Casualty. What we were citing it for is not terribly clear in our motion. I apologize for that. What we're citing it for, Your Honor, is that the Lombardi case basically states that a general liability policy usually does not cover punitive damages. As correctly pointed out in the opposition, Nevada law does allow for the insurance against punitive damages in some cases. In this particular case, there is no evidence at all, whether it's in this case or any other, that there is insurance for punitive damages for real water. And that is the basis of our motion. The plaintiffs argue that perhaps there could be a basis for punitive damages by way of something that happens in this case or by way of expired offers of judgment, or that there could be something that happens in the coverage case. Well, Your Honor, under the summary judgment standard, that's not enough. There's got to be some little piece of evidence, whatever they want to offer, to say that in this case, with the stipulation that they entered into with the bankruptcy trustee, they can recover punitive damages. And we don't see that evidence. Again, they've made potential arguments that something may happen in the coverage case and that's enough. We don't believe under Wood that is enough. That's just hope that something could happen. That's the, what is the classic phrase, gossamer wings?
Threats.
Gossamer thread, excuse me.
Gossamer threads.
It's just, it's hoping that something will happen in the coverage case. I think I've tried to make it very clear on a number of occasions. My firm, my team of lawyers, we do not represent any party in the coverage case. We don't represent any party in the bankruptcy case. We represent Real Water Inc., AffinityLifestyles.com, Real Water Gold Coast in this case. And plaintiffs have sued the first two entities in this case, and there's no basis for them to recover punitive damages from insurance, and that's what they're limited to. And that's the whole issue, Your Honor. It's kind of small.
And as far as, I just want to make sure I'm clear, and I don't know if it was covered, but as far as the bankruptcy action is concerned, Real Water filed bankruptcy. I assume there was a motion seeking relief from the automatic stay of receiving its insurance proceeds. Is that what happened?
Yes, Your Honor. In fact, it's an exhibit to our motion. It is.
Stipulation.
Yeah, the stipulation is part of our motion. It is, I think, right on the front page of it. C, Your Honor, Exhibit C is the notice of U.S. Bankruptcy Court order granting relief from the automatic stay related to Real Water Inc. and AffinityLifestyle.com Inc. And if we look at the language of the stipulation, we'll have to go to page 4, and it says, and I'll just read it slowly, the parties have concluded good faith determined that the plaintiffs here should be granted relief and retroactive annulment of the automatic stay pursuant to section 362 of the Bankruptcy Code for the purpose of allowing them to proceed with the litigation in Nevada State Court in all respects and fully and through final judgment, settlement, or other disposition, including in any all appeals, and for the purposes of liquidating their claims, if any, against the debtor, provided, however, that A, to the extent necessary, the debtor shall be only a nominal party to the litigation. B, in the event that an adverse judgment or other adjudication or determination of any liability of the debtor is made arising out of the litigation, the claimants will look solely to the debtor's insurance coverage, and that's what we're arguing here, if any, for recovery of their alleged claims of damages asserted in the litigation, and shall not seek to enforce any matters against the debtors directly. And then C, the claimants waive any claim they have or could have against the debtor in its Chapter 7 or any rights of distribution of the Chapter 7 case. And so, Your Honor, the plaintiffs have waived basically any claim outside of insurance. The Lombardi case says general liability policies don't generally provide coverage for punitive damages. So the issue is, is there some basis that the plaintiffs have to recover punitive damages from the insurance companies that are defending Real Water in this case? And it was not provided, didn't exist at the time of the opposition. I don't know, maybe they have a different argument now, but that's the issue.
I understand.
Your Honor, I think that me and Joel should argue all the rest of the motion.
Join.
Because this will be brief. Your Honor, this one, to me, is very simple. It's an issue that should be deferred until a later time, depending on what the jury does. But Mr.
But I'm going to tell you what I was thinking about this. I get it. And what Mr. Odou said is correct. In the general sense, most general liability insurance policies don't cover punitive damages.
That's right.
And reading the points and authorities, I guess, and I didn't really know this, but there are certain policies that actually cover punitives.
Absolutely, Your Honor. That's number one.
Okay. And
So,
well, here's my point, and I kind of agree maybe this should be referred, but what do we do with this? We have a nominal defendant in this case. We have bankruptcy court going on, and the order says what it says.
Right.
And I'm not jumping the boat by saying, look, the plaintiffs, as it relates to Real Water, automatically gets a punitive damage instruction. You have to, establish by clear and convincing evidence. You have to establish, I guess, the predicate under 42.005, whatever the statute is, right? I get that. But here's kind of my point. I don't know what to do, because this is kind of a unique issue. What happens if there is a punitive damage policy that covers that? And so, I mean, I'm just kind of looking at the possibilities. And then we go to trial and we didn't have like almost an advisory type decision by the jury. And I understand this, I was really clear. I'm not saying just because this motion is here that I would give a punitive damage instruction. You got to meet the requirements. Fraud, oppression, or malice implied or expressed. I mean, I know what the standards are. And countrywide, and the red flags. I mean, I get that,
That's right.
But, I'm not saying I would give a punitive damage instruction, but what if there is potentially out there a potential basis for that after the evidence is established? And just because I gave one doesn't mean there would be liability for punitive damage, only if it's covered by insurance. And that goes to, I guess, I mean, I don't know, but I'm just throwing it out there. Tell me what you think.
all of those points are well taken, Your Honor. Let's start from the beginning for just a second. This is a motion for summary judgment.
Right.
The standard's under 56.
I understand.
Right now, Mr. Odou, I think, concedes that there is potential coverage through some form of insurance policy for punitive damages. We don't know. But what we do know is there's nothing conclusively saying that there isn't. And we do know that there's policies out there that are not reflected on this, reflected in this motion practice, because there's a coverage battle going somewhere else, not in this court.
Fortunately.
Fortunately.
For all of us.
Thank God. But we also know that there's been offers made, offers that have been denied. And potentially there's coverage because of that. There's potential coverage through an assignment because of that.
Well, I understand what's going on behind the scenes, I do.
Absolutely, Your Honor. And so to foreclose the plaintiffs from seeking punitive damages, not the saying the court would give that instruction at this point, because the court hasn't heard the case. But at the time this case comes to its conclusion in terms of the submission of testimony or exhibits, the plaintiff believes there will be a point to ask the court to allow the jury to consider punitive damages and to see if the jury will strike the box.
Where are we at as far as discovery is concerned as it pertains to the applicable insurance policies potentially? Anybody know what's going on in the coverage case?
Judge, we've identified the real water policies, the Liberty Mutual issued, and there's a debt relief action going on in federal court now. I point out that one of the claims by Liberty Mutual, the express claim, is that there's no coverage for punitive damages. So that's an issue Liberty Mutual has teed up in federal court. We have filed a motion to intervene in that. Our motion is supposed to be ruled on in, I think, September 6th or something like that. 7th, September 7th.
How are they over there in making rulings that quickly?
The bankruptcy court seems to be a little slower than you, Your Honor, to be charitable about it. So in any event, as Mr. Parker said, there's no determination that's been made in federal court on that issue. I don't think there's going to be determination made for at least a year on that issue. So the problem is what Your Honor has alluded to. Here we have every one of the plaintiffs. We think Mr. Belsky's made his man within limits rejected. Mr. Arnone's made his man within limits rejected. Mr. Wu's made the man within limits rejected. On the Ryerson case, the man expires in 32 minutes. I understand that's going to be rejected. But in any event, there's at least 5 plaintiffs. Mr. Ortiz does not have the man within limits rejected. There's at least 4 to 5 plaintiffs that are going to take the position that if they prevail in this litigation, that Liberty Mutual is liable for the entire judgment, including compensatory and punitives, apart from whether or not there's coverage in the policy. These are just standard bad faith principles, Your Honor. So for that reason, we need a punitive determination to allow that process to proceed, as well as with regards to the coverage. So, as Mr. Parker said, I don't think now is the time to make the decision as to whether the punitive claim should be submitted to the jury, but there's certainly no reason to take it out of the picture this time.
Mr. Odou, I want you to have a chance to respond.
Yes, Your Honor, thank you. I just have 2 minor quibbles. The insurance policies have been produced in this case. I'm not a coverage lawyer, don't pretend to be one, don't want to grow up to be one. But they've been produced in this
I don't
case.
even enjoy when I receive from time to time coverage cases. We do, and in fact, I think some of those cases might be heading before the Supreme Court. I don't think they've done a lot with them. And one reason I'm bringing that up, there were some of the cases involving coverage as a result of COVID, and the business interruption and all those cases. And they haven't dealt with that in a long, those have been pending for a while now.
Yes.
Yeah.
I have a partner that does those, and yes, they've been around for a long time. So, minor quibble that, there is the availability for plaintiff to offer proof that punitive damages are covered in opposition to this motion. It wasn't offered. We don't believe it exists in terms of what the policies say. And so if Mr. Parker misheard me or if I misspoke, I apologize, but it does not appear to us that the policies cover punitive damages. Maybe Mr. Parker has a different reading, and that's fine. I would invite that. The second sort of minor quibble is it appears there's a waiver. There is 2 different stipulations to set aside the real water bankruptcies. There's a stipulation that the plaintiffs entered into, which is we waive all of our claims, and there's a stipulation that UNFW entered into, which is we reserve the right to go back against the debtor's estate. And I think that's different. And so, the court's question is, well, what do I do? What does the court do with this? I think the issue is the motion should be granted. It's a bankrupt entity. Plaintiffs did not offer, maybe they've got something now, and that's fine. Did not offer, here's a section of this policy or that policy that covers punitive damages. And then, they've met their burden. But I don't see that. Just because some lawyer in the coverage case says, hey, we want the determination by the coverage court to say there's no coverage for punitive damages, that in itself is just an allegation. That's not evidence. We need evidence, whether it's either, some scrap of evidence, something in the policy that says it's covered for punitive damages. And we didn't see it. So maybe Mr. Parker has something.
And what are the stipulations? Do I have
So-
that?
So I think Mr. Odou read from the stipulation earlier.
It's Exhibit C.
Oh, I see.
Your Honor, we're not seeking to give punitives against real water. The determination is what we're seeking, but in terms of execution and collection, that's not what we're seeking against real water. So I think we're on the same page. I think the purpose of this, the reason why this motion should be denied is because if a jury strikes the box, grants, and awards punitive damages, the plaintiffs will seek that against real water's insurers. So I think that takes care of both Mr. Odou's concerns, and it addresses and allows the court to deny the motion without compromising the stipulation that we did.
Now, here's my question. I'm looking at the stipulation. What does this really mean? I understand this is your stipulation, and I'm looking at paragraph 6 on page 4. And let me see if I can get that to you. And I see you're seeking relief from the automatic stay pursuant to section 362. For the purposes of allowing them to proceed with the litigation in Nevada State Court in all respects and fully through final judgment, settlement, or other disposition, including the E&O appeals, and for the purposes of liquidating their claims, if any, against the debtor, provided, however, and here's a condition, A, to the extent necessary, the debtor shall only be a nominal party to the litigation. B, in the event that the adverse judgment or other adjudication or determinations of any liability of the debtor is made arising out of the litigation, the claimants shall look to the debtor, will look solely to the debtor's insurance coverage, if
Exactly.
any.
Exactly, Your Honor, which is what I just said.
Your Honor, as one who executed the stipulation that was proposed by Real Water's bankruptcy attorneys and agreed to by the bankruptcy trustee, that's basically saying that this is a collection issue. We're allowed to pursue our claims against Real Water, as the stipulation says, quote, in all respects. And then whatever that ends up being at the end, whether we can collect some, all, none of the different damages or categories of damages, that's a collection issue, but I don't think that really has anything to do with what we're able to pursue in this court, in that trial, which should be obviously not determined now, but if we're allowed to go forward on the punitive damages and we're able to recover an award of punitive damages, whether we can collect those from the available insurance proceeds, that's a separate issue addressed in a separate court that is far from undisputed at this point, Your Honor.
And the other thing I would mention.
Well, I think, just to be clear, it appears to me, and you can agree or disagree with this, but section 7, or paragraph 7 of the stipulation that was agreed upon on September 24th, 2021, it says, quote, nothing in the stipulation or order approving is intended or should be construed as altering, affecting, or waiving any rights, claims, defenses, or counterclaims of any and all other relieved debtor or its insurance carriers may have, if any, arising out of or related to this litigation or matters asserted therein. Something.
Exactly, Your Honor. The other point I would make, Your Honor, which I think just makes common sense. If Real Water had an issue with us pursuing this case at this point, then the motion for summary judgment would be as to all claims, not just punitives, but to any compensatory award. But clearly, Mr. Odou recognizes that we have a right to pursue claims against Real Water and recover against their carrier. And the same applies to punitive damages, Your Honor. Mr. Odou was very frank with the court by saying he's not a coverage lawyer. He's not providing a coverage opinion. He's just concerned about his own client, Real Water, being subjected to a punitive damage award. And to the extent that the jury awards punitive damages, we're committed to going after Real Water's carriers and not Real Water. So I think for those reasons, the motion should be denied. But I believe even denial satisfies the concerns Mr. Odou has articulated to the court. Any questions, John?
No, no question.
She's tough control.
All right. Anything you want to, oh, I'm sorry, I got the last word.
Thank you, Your Honor. I agree 100% with Mr. Parker. My concern is Real Water and Infinity and Real Water Gold Coast, and not having them responsible for punitive damages because they're in bankruptcy and they're to be a nominal party. And that's where the tension is. The court rightly points out the waiver language. Where the tension becomes is the purpose of punitive damages is just that. It's punitive. It's to punish. And in this case, there are some pretty significant injuries that will be put before the jury. And for whatever reason, unfortunately, Real Water is bankrupt. And punitive damages are unavailable against a bankrupt entity unless they want to go get in line in bankruptcy court. And they're a nominal party so that the plaintiffs can liquidate their claim against the insurance carrier. I would also add that another, I guess it's a minor quibble. There was one of the offers of judgment that's actually outside of limits. It's more than the policy limits, and so whether or not that particular plaintiff can pursue the claim could have settled within limits is an issue for another day. And then there are two plaintiffs who at this moment have not yet issued offers of judgment to the state of Kathleen Ryerson and Judith Ryerson have not issued offers of judgment. Again, minor quibbles, but I think the court, frankly, I think it's a very interesting legal issue, which is, we have the whole policies and purposes behind punitive damages. We have an issue where certainly the evidence we put forth as punitive damages don't appear to be covered by the insurance. And we have an entity that is bankrupt and can't pay or even be liable for punitive damages. It's a really interesting legal issue. Okay. Maybe the court's got some other insight, but I think this one is a tough call, but I think that the motion should be granted because, again, we produced the policies. The plaintiff wants to come forth with an argument as to how they can recover punitive damages against the insurance carrier. That is not my comment.
And this one last question, so the bankruptcy court is deciding this issue. I want to make sure I'm clear.
Yeah,
Coverage
well,
action.
yeah, so
Coverage
it's,
action.
yeah.
On whether or not the policies cover punitive damages.
So there's a debt relief filed by the insurance carrier. There's a number of different claims in that, and for reasons of potential conflict, I don't want to comment upon the debt relief action. But
No, and I don't want you to do that.
This is a separate claim for relief. It's not just part of the action. It is specifically a claim for relief for punitive damages issue.
No.
yes, and there's others too.
And for the record, I think I do understand what's going on, and here's kind of my point. And one thing we do have right now would be questions the fact as to whether or not the insurance policies at issue cover punitive damages, right?
And
Because
that's why I cited the Lombardi versus Maryland casualty case, because I think that says there isn't a question of that. GL policies don't cover punitive damages. So then the burden would shift to the plaintiff to go through the GL policy and say, oh, but this one does. and they didn't do that. That's my only comment.
How does the burden shift to us with this motion for summary judgment, Your Honor? But I think what he's ignoring here is there's not just the Liberty Mutual policies. Mr. Belsky, the one he said made a demand over the limits, he made a $2 million demand because in that case they had a $2 million primary, that's 1 million preferreds, and they have 5 million excess, which is 1 million preferreds. So his demand is within the policy limits of primary and excess, which is why rejecting it is potentially bad faith. So, but that brings up a whole other issue to the table here, which is he wants to eliminate punitive damages, not just for the Liberty Mutual policies that are subject to the stipulation, but this ruling would also eliminate punitive damages as to the Great American policy, the National Union policy, that's another $7 million worth of coverage. To the extent that there's applicability of the Milwaukee, Tennessee policies, I'm not taking a position one way or the other that.
Good.
Would eliminate any punitive damages that potentially apply on that. And as Mr. Parker already said, we've got Mr. Belsky has made a demand within limits that's been rejected. Mr. Yu has made a demand within limits that's rejected. Mrs. Arnone has made a demand within limits that is rejected. In 18 minutes, 2 of the Ryerson errors will have a rejected demand, which Mr. Odou says is coming. Maybe it's already here, I don't know. So basically, out of the plaintiffs going to verdict against Real Water, the only one that doesn't have a demand within limits rejected is the estate. Okay? All the heirs will, not the estate of Mrs. Ryerson and Mr. Bottice. And, you know, we intend probably to make a settlement demand from Mr. Bottice to, can't make an offer of judgment now, it's too late. We can still make a settlement demand that probably be rejected within the limits. So potentially, we're gonna have all 5 of them make demand with limits that are rejected. And, you know, like I already said, we're covered by more than just the Liberty Mutual policy. We have the Great American National Union policy. We potentially have the Real Water Tennessee policies. We have a couple stray policies out there. So to suggest that we have all these policies, not one of which policy has been brought to the attention of the court, not one of which policy provision has been cited by Mr. Odou to support his burden on the motion for summary judgment. It's not our burden. But to suggest that we should just throw out punitive damages now and give the insurance companies all a reward because it minimizes the amount of the judgment for bad faith purposes and or eliminates the amount of the punitive judgment if we win on any coverage litigation that as to whether or not punitives are covered. That's just not appropriate, Your Honor. And then his final argument is what I really take exception with, which I call the hobo versus the billionaire argument. His argument is that you can't award punitive damages against hobos because they have no money. It's only billionaires that get punitive damages. That is not what our statute says. The primary reason to award punitive damages is reprehensibility, okay? Reprehensibility. If he wanted to raise a defense that punitive damages were not appropriate for financial reasons, that's called the annihilation defense. That's Ace Trucking, the Ace Trucking case. It's reflected in a jury instruction. It's his burden to present proof that he is not financially capable of paying punitive damages. He didn't do that. He did not do that, Your Honor. So financial condition doesn't even go to the jury in the punitive phase because he didn't raise annihilation as a defense, and he can't raise annihilation defense because we've already agreed not to pursue the punitive damages against his client. So there's no financial consideration that's going to be heard with regards to Real Water in the punitive phase. There's just going to be reprehensibility and the other punitive factors. And what the jury does, who knows? But unless we do it, unless we get the punitive verdict, we can't follow up with the bad faith issues. We can't follow up with the coverage determination as to whether there's coverage for punitive damages. So to cut it off right here, it would be inappropriate, Your Honor, and that's the reason this motion should be denied.
Let's not forget that the purpose is punishment and to send a message to the others.
We're getting well beyond really what the call of the question is.
Right.
This is, I mean, I'm looking at the, right, I mean, I'm sorry, I'm looking at the ruling, and this was signed by the bankruptcy judge.
Judge Koch.
Yes, go back to number 6. And so I'm looking here, and I will admit, I mean, this is about the only area I have experience from a bankruptcy perspective, because many times I've gone and sought relief from the automatic state proceed against insurance proceeds. I understand how that works, and you got to get the trustee on board, and you file the motion, and so on and so on. So both sides have, I understand both arguments, but really, is this the issue? Here's my point. It says, if you look at the extent of the order, and this is paragraph 6, and it would be, I guess, subsection B in parentheticals, which is quote, in the event that an adverse judgment or other adjudication or determination of any liability, understand it says any, it doesn't say compensatory, it doesn't say whatever punitives, it doesn't say actual, it doesn't say that, it says any liability, which is fairly broad. I mean, it just is, that means any liability. And it can be a punch in the nose, or it can be negligence, right? And it says any liability. And the only reason I use a punch in the nose, that's an intentional tort, and we know what happens there, right? But it says any adjudication or determination of any liability of the debtor is made arising out of this litigation. The claimants will look solely to the debtor's insurance coverage. Close quote. So it seems like to me, what that's saying is this: look, debtors, you're hamstrung. If you're going to collect any monies in this case, it's going to be, first you have to win in district court. And secondly, you're going to be limited to the insurance coverage that's available. Now, I'm not sure, and I don't know, but this is a coverage issue, and it's been my experience that the coverage lawyers are pretty smart guys. And yeah, they typically are. They are. But my point is this: don't they decide that issue? I mean, when you dig down deep, don't they decide that issue? Because, and here's my point, say hypothetically, there is an award of punitive damages in this case, for all practical purposes based upon the bankruptcy advisory decision, based upon facts that have been adjudicated in this case. Like I said at the very outset, I'm not making the determination whether I give a punitive damage jury instruction at this time. I haven't listened to the evidence. Maybe there's a motion down the road on that issue. But when I look at the order, it says any liability. And then there's a limitation that no matter, it could be $1 zillion, Mr. Parker, you're not getting it unless there's coverage.
That's right. You know, I asked Mr. Odou if I could make a point. I want him to respond to it. I don't want to steal his, the thunder of his last comment back.
But is there a problem with my?
No, I think you're right on. The only concern I wanted to raise, because I believe you're 100% right on it, is that, and Joel, in all due respect, I want you to respond to this. Does Joel's motion in and of itself violate that stipulation? Because that, and I want
to make that rule.
I know, I'm saying this so it kind of reverberates in the courtroom, but the motion, the stipulation says that he, Real Water, is allowing us to go forward with the idea that we can only recover against the carrier. So by bringing this motion, in and of itself, it appears that he has gone back on the stipulate, Real Water, not you, Joel, but Real Water, has gone back on the stipulation. And so I only brought this up when he suggested there was some form of waiver. Well, in reality, any motion that contradicts that stipulation, in my opinion, would be a violation of that motion. So I think offering to defer actually takes out of Mr. Doule's situation right now the possibility that he's violating that stipulation by bringing this motion. Because he is attempting to prevent us from seeking damages that would be recoverable only against the insurance carriers and not Real Water.
I have no comment.
I just want Mr. Doole to think about that.
I'm not touching that.
I appreciate Mr. Parker's position. Our position is we don't want there to be a waiver of the stipulation in terms of this motion. This motion seeks to make sure that the recovery is limited to insurance coverage. Where I started is kind of where I'll finish. We don't represent the insurance carrier. Our interest is to make sure that in any way possible, real water affinity, real water build codes are taken out of harm's way. I do want to quickly comment, just so the record is clear, as to some of the things Mr. Kemp said that were factually inaccurate, only to say some of those things were factually inaccurate. I'm happy to meet and talk to them about where some of those mistakes were made, but I don't want there to be a misunderstanding that somehow we're misrepresenting the amount of coverage, because it appears the plaintiffs have a different view of the amount of coverage than we do, and we believe it's less. I'm happy to talk to them off the record on that. And the final point was somehow Real Water Tennessee got in the middle of this, and they're not part of this motion, so.
No, they're not part of it.
So anyways, Your Honor, I think it's
Mr.
very
Cavanaugh, I'm not
interesting.
gonna have you get come up here.
They're not part of this. It's a very interesting legal issue. I think that, you know, the court has a couple of choices before it. It's call, no call, or pass, I guess. And
I'm passing, gentlemen. I don't mind
Pass.
telling you that.
Pass is understood.
Yeah.
It's an interesting legal issue, and we wanted to make sure that there was no argument that Real Water is now waiving their bankruptcy and exposing themselves to punitive damages by not asking for this relief.
I understand.
Thank you, Your Honor. We're close to 5, but
Yeah.
maybe we have some housekeeping to do.
Yeah, and what I'm gonna do, I think, and for the very reason, and understand this is a discrete motion. It has nothing to do with chapter 42005 or whatever punitive damage requirements are under state Nevada as it relates to various types of claims that might be the basis for punitive damage award. But I'm looking at through this lens, and it's very straightforward as far as my determination is going to be made, because there's two overriding issues here. Number one, you do have a stipulation in order signed off by the bankruptcy judge. Just as important too, the basis for the stipulation is sounded in section 362 of the bankruptcy code. And I understand what that essentially does, and as far as seeking relief from the automatic stay, that's something that's routinely done in court cases. And as a matter of law, you're limited to the insurance proceeds. That's basically what that means. However, and this is my point, and this is why I'm punting, and I'm going to deny it without prejudice, because there's a coverage issue out there somewhere and being litigated. I have no clue what the policies provide, and hopefully I'll never have to get involved in that issue. But secondly, it appears to me, when I just look at the order, just knowing how chapter 362 of the bankruptcy code works, even if the stipulation was not in place, and there was an order issued, signed off by the bankruptcy trustee, as a matter of law, if this case proceeded, it would be limited to what available insurance proceeds are there. Nothing more, nothing less. No waiver by anyone. But if I get involved in this issue, I could unintentionally impact the coverage case. I could impact the bankruptcy case, and just as important, I shouldn't do anything that might be in violation of the automatic stay. And so when I look at this, as far as what happens here, it says, bottom line is, it says, any event that an adverse judgment or other adjudication or determination of any liability of the debtor is made arising out of this litigation. And my point is any liability, you know, it's kind of underscored. And so that's why I'm punting on it. I want to make sure this is clear too. It's denied, but I want to make sure that put this in the order, that I'm not giving my decision has no impact or any value as to the coverage actions and or what's going on in bankruptcy court. And I defer to whatever they do because that's not in front of me. I'm just following the mandate of the STIP and order that was signed by the bankruptcy judge, and also chapter 362, which I have limited familiarity with, but I do know something about it as it pertains to the automatic stay. All right?
Yes, Sean.
Thank you, Your Honor.
Thank you.
So, it's 7 minutes till it's time to go. What time do we meet tomorrow? I have no idea.
10:30?
10:30.
And on the housekeeping, I think Mr. Neale and I have agreed that we're going to keep it 19 till sometime next week. So that means we would move to the water motion remaining number 3 would be the next one. Which, oh, excuse me, that one we're discussing. So 3 that gets resolved. 6 is the next one. 6.
Real water.
Real water 6. Real water 10. Real
Did you say
water
9? Yes, ma'am, and then 9?
Thought we'd submit 9 on the brief.
Yeah, I thought it was in the.
Yeah, that's why I said that. Okay. So we will do, let's start with again. 6, 9, go to 11. Then we go to Milwaukee's motion for summary judgment on practical causation and superseding clause. I don't know if we're ready to do that tomorrow.
I won't be ready.
Okay, yeah, Mr. Robbins has, I don't mind skipping over that, John. But if we skip over the 3 Milwaukee ones, we're back to 21 on the call, which I think we also want to skip, right?
Rob?
Yeah, and Your Honor, it may be something after the weekend that we might submit some of these as well.
Mr. Robbins, I want to defer to what you want to do.
All right, thank you.
All right, then I think that takes us to the plaintiff's motion on the 22, 23, and 20, well, 24 is already resolved now. 24 is moved, that's another, well, potentially moved. Yeah, I think that'd be plenty for Mark.
Well, we have the jury issues too, so
Yeah, yeah, I'm just talking about tomorrow afternoon.
you're an optimist.
Well, I'll mind, remember.
So Tori, go for it. You make the motion.
Real water is motion eliminating number 3. Real water is motion eliminating number 6. Real water motion eliminating number 10. Real water motion eliminating number 11. Plaintiffs motion eliminating number 22. Plaintiffs motion eliminating number 23. And I'm going to leave plaintiffs motion eliminating number 24 on the calendar because it's only potentially moved. So we have a hard, fast ruling, it was down.
Thank you. And so are we all in line? We're ready to go, 10:30?
Yes, Your Honor.
Yes, sir.
Okay. Enjoy your evening.
Thank you.
Thank you, Your Honor.